Okay, so good morning, everybody, and welcome to the first session of the first webinar, really, of the SLP, of the Tech and Law Committee of the SLP. We have a lot of events planned over the next 18 months. We have trainings with exciting resource persons. Some of these trainings have certificates. Some of the sessions are physical, while others are virtual. Some are free, and some are paid. Some are free to members of the SLP, but paid for everybody else. I invite you to follow our social media handles, which will be shared shortly and also sent to you via mail, along with the social media handles of the SLP. If you're not yet a member of the SLP, please visit NBA-SLP.org and register so that you can have access to all our activities. And we have a whole lot. So this is just one committee of the SLP. There are several other committees, each have exciting activities and events that are going on. So do well to register and be a member so that you can enjoy all the benefits. I know that, for example, there was a litigation committee event that took place last week. It was free for SLP members, but paid for everybody else. If you had joined, if you had been a member of the SLP, you probably would have been able to enjoy it free of charge. But now, those who attended had to pay. After this event, we'll send a post-event survey. Please respond to the survey honestly so that we know what ways we can do better and improve the situation so that we can serve you better. Before I close, I'd like to thank the leadership of the SLP, particularly the chairman, Mrs. Bomala BSAN, for putting together the entire team, really, and for putting together the team that's bringing this work together. I'd also like to thank Inem, who is vice chair of this committee, and my madam at Digital MBA, all our collective madam at the Digital MBA. I'd like to thank all the members of the committee who have put together this work, and Fadekemi. So thank you all and have a great event. And before I forget, happy Easter. Now I'm handing over to Inem to invite the chair and we can go on. Thank you very much.
Thank you very much, Mr. Fernandez, Marcus-Obiene. Thank you so much for that. It's a privilege to be here. My name is Inem Dike, and I'm excited to be here. I am the vice chair of the SLP Tech Committee. It's a brand new, fresh out of the oven committee, and we're very excited about all the tech-enabled conversations that we'll be having. So this is our first outing. And in order to open this webinar, which is on data protection, the do's and don'ts, I'm going to ask our able chairperson, Mrs. Boma Alabi, SAN, to please give us her opening remarks. Thank you very much, ma'am, and over to you.
Thank you so very much, number 6, for this very kind introduction. And thank you also to Fernandez Marcus, the chair and vice chair of our committee. Thank you to all who have worked with you to put this together. I personally am so excited. Like you rightly said, this is fresh out of the oven. This is timely. This is necessary for us to practice in this profession today. We have to understand about data protection, and we have to understand how wide-ranging data breach could be, and therefore the importance of us protecting not just our data, but the data of our clients, which we hold. You remember, we have privileged information which probably nobody else has apart from their doctors or possibly their priests and pastors. So for instance, we would have typically clients data pages of their passports, for instance, depending on when you're going through your KYC on your clients. We would have information on sensitive business transactions because we're advising on the transaction before it even happens. We would have information about their marriages and details, painful personal details, because they're going through a divorce and it's a legal process where we're involved. And so if there's a breach of our data, potentially that could impact on all of our various clients and their personal data that is kept in our systems. And I'll give you an example. I was in Puerto Rico 3 weeks ago for a conference. And in that client seminar, the clients were talking about the breach of a lawyer's data, which led to the hackers stealing their information. They were not targeting the lawyers, they were targeting their clients. Stole their information and then approached them to pay in order to get the information back. Otherwise, they would send it out and make it public in the dark web. They eventually had to ransom the information. And it wasn't their systems that was breached, it was the lawyer's system. So this topic, without further ado, is so topical, so necessary. It has to be the start of a series of conversations, because I'm sure we cannot finish this today. But I thank my able, vigorous, and amazing team, the committee, for the work they're doing. I am so enthused. I know I've got the right team on board. And I join Fernandez Marcus in saying to you, join the SLP, because it's not always going to be free, but it's likely going to be free to our members. So the sooner you join, the better. And there is no conflict. People tend to do it, but I'm at SBL. There's a reason I created various sections. They're dealing with different things. So I'm a member of SBL. I'm a member of SLP. I'm a member of the Women's Forum. And if I was still a young lawyer, I'd be a member of the Young Lawyers Forum too. But I am not, so I'm a patron. So welcome all, and thank you very much for the opportunity to welcome you. Thanks to our speakers as well, of course, and the delegates. Thank you.
Thank you so much. Amazing to hear from you. Thank you very much. I'm pretty sure that if I close one eye, I'll think that you're a young lawyer. On the other hand, you look like one. Thank you so much, ma'am, for the introduction. We're very excited about this committee. It's great to have a lot of people show a lot of interest. We have a lot of people registered. So without further ado, I'm just going to quickly jump into the nitty-gritty of things, and I'm going to introduce the first speaker. But please, before we do that, I'm just going to talk to us about what we expect from today's event. There's going to be a practical aspect of today's event. You're going to please ask your questions on the platform. And there's no question that is irrelevant. There's no question that is lame, so to speak. So feel free to ask questions, post them in the chat box. As soon as I see them, I'm going to throw it to the right speaker. So a question concerning data protection, question concerning privacy. If you want to ask questions about even how to make money from it, what are the do's, what are the don'ts, there's no question that is not, we're not going to, as much as possible, take. So quickly, I'm just going to introduce Mr. Babalola. So Mr. Olumide Babalola teaches law at the University of Portsmouth and the University of Manchester in the United Kingdom. He's a digital rights, privacy, and data protection lawyer in Nigeria. He holds a master's degree in international commercial law with ICT and commerce from the University of Reading in the UK, and is currently a PhD candidate at the University of Portsmouth in the UK, where he's conducting extensive research on the concept of privacy within the jurisprudence of Nigerian courts. Olumide's pioneering litigious work around privacy and data protection has seen him litigate the subject up to the Supreme Court of Nigeria and the Community Court of Justice, ECOWAS, in demonstrating his knowledge and expertise in election, the first Court of Appeal decision on data protection in the case between Digital Rights Lawyers Initiative and National Identity Management. Hold on, please, let me just put that. A National Identity Management Commission, where the court extensively identified the nexus between data protection and rights to privacy under the Nigerian Constitution. Olumide has published 7 law books to his credit, including Case Book on Data Protection, Privacy and Data Protection Law in Nigeria, Digital Rights in Nigeria, through the Cases 2022. emerging jurisprudence, and others. He has also authored many academic articles published by international and local peer-reviewed journals. Without further ado, I would like to welcome Mr. Olumide Babalola for him to give his presentation. Welcome, Mr. Babalola.
Thank you, Inemesit, for the introduction. And also, I'd like to thank the NBA-SLP for the invitation as well. I do not take this for granted. Please, if you can allow me to share my screen so that I can quickly speak to it. But I also want to take this opportunity to invite those of you that are not aware of the privacy conference we're having in Lagos next week. It's also another avenue to share, to further discuss privacy issues affecting either the profession or all other industries. So, I mean, I put in the chat room, I actually put the website where you can register and attend online or offline, I mean, on-site, whatever works for you. Okay, thank you for enabling me to share my screen. So I understand I'm speaking on the do's and don'ts of data protection in legal practice. The learned SAN, Mrs. Boma, she's spoken, and she's spoken about some of the issues that, yes, we would have to deal with in the course of legal practice. And anything I'm going to say here today, I am also affected. I am not a saint. I am not perfect. My firm also suffers some of these issues. But the more we talk about it, the more conscious we are, and the more we try to tackle these issues and take care of them before they become bigger issues. Because trust me, until one suffers a data breach, or a client suffers data breach in one's custody, or a client makes a demand that one is unable to answer, then that's when we begin to take some of these things seriously. I remember a couple of years ago, a client just appeared out of the blue and asked for a judgment we obtained for her about 7 years ago. We had given her copies of the judgment, we had given her copies, but she wanted additional copies of something. And for some reason, we couldn't find it. Or she wanted a document. For some reason, we couldn't find it. Normally, where there are data protection policies, or where there are data protection documents from the bar now, not even from the lawyers, from the bar, we can easily say, oh no, our retention schedule, our retention policy, or the retention framework is that we only keep this document for 3 years or for 4 years. I remember I spoke at the NBA knowledge sharing session in Lagos about 2 years ago, 3 years ago, and I made that poster that as law practice stands, somebody's mic is on. You might want to mute your mic, please. Thank you. So I asked the question that as law practice stands, what is the understanding on how long you can keep people's document, keep clients' document? And we had varying answers. So I had to even write articles on it. Invariably, we don't have a direction from the bar on how long we can keep this document, because a client can come back in 20 years. Something happened. There's a case we're just briefed, and a lawyer had handled the case at a point. They discontinued the matter. The lawyer handled it in 1991. The lawyer is now a senior advocate. Handled the matter in 1991. They are discontinued the matter. The client does not have a copy of the processes. We need the processes to be sure of what they actually litigated, so that we know whether we are reproducing, or we know whether it is res judicata, or whether it's been decided. We need all those things. Now, reaching out to that lawyer now, the lawyer would most likely just say, oh, we don't have it again, or it is in our archives, or we can't even. So these are data protection issues that can actually lead to issues. Now, what are the do's in data protection? Data protection is not anybody's exclusive reserve. All of us as lawyers need basic, let me start from basic understanding of data protection. You can't run away from it. It crisscrosses almost all the practice areas. Labor law, you find data protection there. Contract now, standard contractual clauses in Europe, even in Africa, would have data protection because data would exchange hands. Land law, you are using people's data. Somebody wants to buy land would most likely exchange, or if you are doing whatever transaction, or you are doing litigation, or you are doing is a transaction, is a commercial transaction, data must exchange hands. Maritime, family law, there is hardly any legal area of practice that you will not talk about data protection. Third, there's none. So basically, everybody should be interested in it. Everybody should have an understanding of it. Everybody should know how it impacts his or her law practice, whatever you do. Confidentiality, we all know that under the RPC, but data protection takes it further. So confidentiality talks about keeping secrets. That's what confidentiality really speaks to under the RPC. But data protection goes beyond that. If you're keeping the secret, you are keeping documents safe from unauthorized access, from theft, from destruction, from compromise, because the documents that lawyers handle, they are sensitive documents. Any information that anybody surrenders to a lawyer, they are sensitive information, or they are very confidential information. So you need to keep them. You need to secure them. You need to be sure that only people who need to have access to them have access to them. Then data minimization is one of the principles of data protection. When you are preparing documents, and lawyers do that a lot. I think gone are the days of verbosity, except with just what we practiced in the olden era. You don't need to have 600 pages, 200 pages. And I tell my juniors, now we need to understand that the workload of the judiciary is even crazy. So if you are filing a process and you can't go straight to the point, somehow you would shoot yourself in the leg because you will just pack so many, you even confuse the judge. The judge will not even be able to see. So data minimization is just don't use more than what you need. You are writing a letter. I've seen people write ordinary letters, 10 pages, letter. Don't give more than what is necessary. Some people are responding to letter of demand. You will write everything. You are even giving your opponent arsenal to attack you. So in terms of data, collect only what you need from client. You are filing filing a divorce case. What are the things you need? Sometimes I tell clients, please don't tell me all these plenty stories. I don't need it. Have you lived apart for 1 year? That is all. Whether your husband was smoking the boo or the wife, don't write all those things and send to me. If you have lived apart for 1 year, it is enough under the law for you to get a divorce. The children, how many children do you have? I just need maybe their birth certificate to show their age. I don't need their pictures. You work somewhere, maybe we just need to show what your husband earns or what the spouse earns in case we want to get alimony or get maintenance. And this cuts across every other practice area. I just use that as an example. Don't collect more than what we need. You see some lawyers file so extremely bulky. The more documents you collect, the more data breach exposure you get. Whatever you need. In fact, some lawyers say they used to collect original from the beginning of the case. Why? Why do you need to collect the original? The case might not go to trial in 4 years. You want to keep people's original in your office? What if it gets stolen? What if it gets damaged? What if anything could have happened to it? Just get the photocopy you need. When it is time for the trial, you can collect all the original. Except you have special reasons to not collect original. Now, consent. Many law firms do this thing, big law firms especially. We use employees' data anyhow because they are our employees. Remember from the beginning I said it. I am not excluded from all these things, but these are things we need to know. You see law firms using their employees' pictures on their website. You see law firms using their employees' voice notes for advert or for event or for whatever. Even though you see consent, that consent might not even be valid in certain cases because most employees cannot deny, they can't deny their employers' consent. If you say we are doing Happy Women's Day, everybody should take pictures. Some employees might not like taking pictures, but because it is the law firm's practice to do International Women's Day, everybody parks, they take their pictures, they put it online, they splash it on social media. Some employees might not even be comfortable with it. So in certain circumstances, you might have to let the employee know that there is no consequence about you denying your consent. We just need to tick the boxes. We just need to be sure. We don't want to assume consent. If you don't want to be part of it, please just stay clear. It is possible. Data retention, I've spoken to you about it before. For documents, we should have retention period. This document, for how long do you want to keep it? This document, why should we? People are sending proposals. People are sending CVs. People are sending processes. For how long are we keeping this thing? Because the longer you keep it, the longer the owner has the right to demand for it. I can come back in 20 years and say, you have a copy of my court process with you. Give me a copy. But you have to clearly define these retention periods. Then data protection considerations. In your letters, you have letter of engagement to the client, letter of instruction. You might want to insert data protection clauses there. That although we are collecting this document, we'll keep them safe. Give them some assurance that you even understand data protection. We'll keep them safe. We will not keep them for longer than is necessary. Maybe 3 years or 4 years after we have finished your matter or you have disengaged us, we don't have your file anymore. So you shouldn't come to us. That's when some clients debrief lawyers. When you brief another lawyer, 3 years, you don't have to come back to me and say I should give you a document. I don't have your document again. I have given all the file to your next lawyer. Just go to him and whatever you need to get it. Then when you draft contract also for clients, insert data protection, especially for relationships that impact data protection. People are doing advertisement contract. People are doing recruitment contract. People are doing even shareholders agreement. That could be cross exchange of data. Just insert it for protection. Then we need to be able to demonstrate compliance. For every law firm that has a website, start from there. Have a privacy policy or privacy notice on your website. Just start from there. That is the easiest place to start. Then also now there are regulations that might require lawyers to register with the NDPC, although there's still some back and forth on it. But when it happens, I think lawyers should do it. We can hide under the umbrella of 10,000 registration because you want to scale. And if you're dealing with international organizations, they want to be sure that you even understand data protection. Let me quickly go to the don'ts because Ridwan also has some things to say, and I don't want to. I've already spent like 12 minutes. Now, this is what almost all the lawyers do it. You share processes with reckless abandon. We say because it is a public document. No, even if it is public document, your client has what we call reasonable expectation of privacy. I'll give you an example. We were handling one very highly sensitive divorce matter in 2021. In the process, or part of the process that we found, WhatsApp chats were there. Highly sensitive, graphic. It was about infidelity. Sorry, somebody's speaker is on, please. It was about infidelity, and you can imagine the content of those WhatsApp text messages between the person, the alleged co-adulterer. The content was so graphic. So when judgment was given, yes, anybody can argue, yes, or even court process. You can argue that court process is a public document. But should it be the lawyer that is representing one of the parties that is sharing such processes with the name of the parties? It's a court process. Whether you are sharing drafts. I know lawyers ask for draft a lot. Oh, give me the precedent of this one. Give me the precedent of this one. And you will see the names of the parties. You will see their addresses. Some people will even ask, send me precedent of how to unlock or unfreeze bank accounts. Somebody who has unfrozen another bank account will send the precedent as is, with the name, with the number, with the telephone number, with the bank account. As lawyers, I think we should do better. You can share processes, but redact this document. I'm saying it, I'm not a prophet of doom, But in the nearest future, people will start suing lawyers for invasion of privacy because you are the person's lawyer does not give you the right to now expose the person to the entire world. These are things we should do better. Now, when you send group emails also, even the NBA does it. I'll keep saying this thing. For as long as the NBA continues to invite me for events, I will keep saying it because we need to get better as an association. NBA does it. NBA sends group emails, and you will see everybody's email on it. Gone were the days when emails were not sensitive personal data. Now, emails are now extremely important. Everybody wants to keep their email safe. They can, through the email, hack into your system. They can now, through email, hack into your WhatsApp. They can, through email, hack into your bank account, especially when the emails are connected. So, I mean, we need to be careful with how we send all these group emails. Then, when you want to process sensitive data, you must understand whether it is under the exceptions. For example, you want to process somebody's health, somebody's political opinions or affiliations, somebody's trade union. Right now, those are very volatile. Somebody's tribe. In some places, if you belong to a certain tribe, you know what you will face. Law firms that use CCTV, let there be notices. It is important. If you put CCTV on your premises and I come to the premises without notice, you are violating my privacy because I need to know so that I know how to behave. The way we behave behind the camera is not the way we behave in front of the camera. So, I mean, I just need to know. It's your right to police your premises with CCTV, but it's also my right to know whether I want to even come there or not. I always use an example of events where they have CCTV. For a married couple, you might be going somewhere you didn't tell your spouse, and you didn't expect that there will be CCTV or cameras there. If you go there and camera picks you, and your wife or your husband sees it, that thing is enough to scatter some marriages. So, I mean, we don't even know how sensitive these things could be. So, please, using employees' picture on social media, identify a legal basis. I'm coming to work for you as a lawyer. It does not mean I must always be on your social media, except it is connected to my contract. We must find a way around it. We must not continue to take it for granted. Not everybody likes the camera. Some people don't like it. When you use employees' pictures for promotions, also find a legal basis. Either you want to use contract, I don't know how you are going to use it to say it is tied to their contract, or you want to seek their valid consent, because not all employees like it. Training, these are the do's. Let's always go for training. I am doing my PhD in privacy. I am still learning. It's a lot, but I am learning. We all need to keep learning because there are trends that keep coming up every day. Thank you for your time. Ridwan will take you further from there.
Thank you so much, Mr. Babalola. It's deeply appreciated. That was very insightful. I can see from the comment section. So we've got I can't go through it all, but we've got from Carol Branch, Kaduna, Umuahia Branch, Lagos. People are already asking for the slides. Yes, you're on this call, you registered. Definitely the slides would be shared with everybody who had registered. Like our able chairperson mentioned, it's going to be free for today, but going forward, there will come a time that it will not, this kind of access to information will not be free. So we would urge you to please register with the SLP so that you can have access to this information. The time for question and answer will come for both speakers. So please, we want to see your questions in the chat box. The link for the upcoming conference, it was posted here earlier. I've seen a comment in the chat box. Please, we would, Mr. Babalola, if you could please post the link again so that those who are interested in attending the conference can show up. Now, I'm just going to quickly introduce our next speaker, Mr. Ridwan Oloyede. He's the co-founder of Tech Hive Advisory, where he leads the technology policy team. He advises on global data protection laws, program implementation, and monitoring. Ridwan holds a Master in Law and Technology from Tilburg University. He's a policy advisor and researcher. He's also the co-founder of Privacy Lens Africa, Privacy Bar and Bands, and where he uses visualization and podcasting to draw attention to data protection in Africa. He's a member of the Africa Digital Rights Network, the Africa Law and Tech Network, Africa Data Governance Initiative, and the Privacy Alliance. He also sits on the advisory board of Continental Approach and is a trustee of the African Biodata Foundation. Mr. Ridwan is a fellow of the Information Privacy of International Association of Privacy Professionals, and he contributes his expertise as a research fellow at the African Academic Network on Internet Policy as a member of the Privacy Working Group at the National Institute of Standards and Technology. He's also a designated as an expert of the Data Protection Unit of the Council of Europe. I wish we could give you a virtual round of applause, Mr. Ridwan Oyeloyede. We hereby welcome you to please speak and give us of the length and breadth of your expertise. Over to you, and thank you very much.
All right. Thank you very much, Massive. Brilliant background that's been done already by Olumide, and I'm basically just building up on what he has done. Olumide has set the ball rolling with valid concerns about common practices, common things that we often neglect. And some of them are just not, they've evolved from just being common errors to being customary. So I guess the whole point of this conversation is just to beam some light on it, but then take us from self-conscious, take us from self-conscious and bring it to our self-awareness. So for me, I'm just going to focus on some of the case studies and also some of the things that Olumide's presentation didn't account for, because it's almost practically impossible to speak about everything within the time that we have. So as law firms, rightly as the learned SA said in an introductory speech, and also the background Olumide has provided, is that there's so much that confronts us and that there's so much risk. On one hand, there is a risk to us being victims, we being subject of attack, but also because there's interest in the kind of confidential and sensitive data that we hold as law firms. But also as law firms, we sit as an institution that holds some of the most valuable information that you can think of. From proprietary information when you work on intellectual properties, to work around very touchy issues like aside beyond you having the default confidentiality obligation as a lawyer under the rules of professional conduct, you also realize that there is also way bigger obligation on you, because the data protection law creates some new set of obligations on you. There's a consumer protection law that also speaks to you. And maybe on the margins, you also have a couple of things that could also flow from even things like competition law. But nonetheless, speaking on some of the examples of what we've seen so far, in 2023, a New York-based law firm, for example, suffered a data breach, which in turn affected over 152,000 people. And these are things that it's not just about saying we are IT compliant because we have a couple of computers. And if you're lucky enough, you bought like office-specific computers for your staff, which maybe helps you minimize risk, because then you're able to also draw the line between people separating their personal lives and also from the business data, for example. Then you also have in 2021, there was also a data breach that also occurred with thousand people. Move on. Also, somewhere that humans are basically just holding the data to once, and then you're asking people or whoever it is that is impacted to pay to get the data back. But these days, the nature of ransomware has even evolved beyond just trying to extort. Now people just dump and just release this data, and sometimes it's really hurtful. I've seen the different manifestations of these things. In this particular case, over 42,000 clients and staff. Some of us are probably familiar with the Panama paper scandal. That was like a whole big story because it also impacted quite a number of folks from this side of the world. So what you see with things like this is also with the Panama Papers, a law firm was also involved. And this spiraled so big because it became global news. The Guardian first, doing all the investigation, pushing out the data, pushing out these stories, linking big personalities, politically exposed people, and all of that. Whether this is some social good or whatever it is, it's a different conversation. But then it's a law firm. it suffered a data breach that led to, exposure of things they already gave some sort of assurance they're going to give confidentiality responsibility, the way they had confidentiality responsibility. But what you had was, it was so bad that the law firm at some point need to actually close down. Sorry, in 2018. So coming back home, there was also like an incident with a South African law firm where there was like some sort of like an interception with an email that was sent to a client where account number was then changed in the PDF document, and then the client sent money, thinking she was sending money to the law firm, but then the money went to these criminals. The law firm went ahead, sent like a follow-up to the client, asking for the money, second request, and then this led to back and forth, 3.5 years of litigation. Eventually, they had to pay over 5.5 million rand to clients for damages and also of cost of filing the case. And I think another interesting one, which is something that comes from one of the mistakes Olumide highlighted, was a Spanish lawyer that was actually sanctioned by the Spanish Data Protection Authority. And in this case, I think it's a common practice because, interestingly, I also had like a stint in a law firm, 8 days of my career, where we take court paper, maybe the ones we printed out that we're not using anymore, and then we flip it over to him. So in this particular lawyer's case, was reversed, printed a court process on it and filed it. And then the client got ahead. I mean, the question is, how much is actually like a whole roll of paper? And in this case, the lawyer actually got sanctioned about 2,000 euros. And for me, it's one of those really funny use cases that I use when I speak to lawyers about how our carelessness about our responsibility that we have to our clients, but more importantly, our house cleaning could go from 0 to 100. And beyond that, what are some of the things that I think we could also keep an eye out for? Whether you realize or not, as a law firm, you're a controller. Some days you're also playing the role of a processor, especially when you're acting under strict instructions. But beyond that, you also, because unlike a company that can decide to say, oh, my business model is going to be B2B, that's business to business, or my business model will be B2C, business to customers. You're, in most cases, interacting with a whole lot of humans. Some of us has built community as law firms, we have mailing lists, we have a bunch of things that means beyond the corporate clients that you have, there are also individuals here and there are ex-employees numbering in their hundreds. If you're a legacy firm, maybe more. There are current staff that you have and you have obligation to them. And in part of this is also the data protection creates some bunch of rights. And it also means that you need to have like an internal mechanism to be able to respond to these rights. So what you see is it's very easy to miss. An ex-employee comes and they're asking, like, pull down my data, pull down my information you have on your websites. I'm no longer working with you, especially if it didn't end well. I mean, Olumide already mentioned that, no point flogging it. There's also a question around information disposal. A lot of us don't shred properly. We probably just easy to resemble. And beyond just not also disposing information properly, we pack all these stack of stack of papers, the secretary picks it, sells it to the suya guy. I get to know so much about things I have no business knowing out of my own way, simply because as a law firm, we don't have proper mechanism to dispose. And nobody is asking you to go make like key investments, especially as a small size law firm, for example. Nobody's asking you to buy a shredding machine. Even if you're not using a shredder and you want to dispose manually, make sure you dispose properly such that people information, that waste documents, that paper you have to print all over again because you don't like some contents in the draft that is so in my days working as like a lawyer in a law firm, half of some of the things that I know or have no business knowing was because someone probably kept legacy templates and information are not properly redacted. And that was one of the things Olumide also highlighted. But there are also issues when we don't know when to even update software and systems. Again, it's not just about being able to scream and say we're IT compliant. Are you actually updating your enterprise solutions? Are you using free solutions? Or is it just free for all? It doesn't matter what solutions employees are using to get the work done, whether the Microsoft is, I've not been paid to do that for any brand, but whether it's, a lot of us work remotely these days, and it simply means we need to work in shared environment. So whether it's 365, whether it's Google Workspace, we have, so again, do you just leave people to do things? And I also know like a bunch of early days as well, one common thing is law firms not even having their own dedicated domain name, not having their own specific email addresses, and everybody's basically working on Gmails. Clients' information gets shared with personal emails. The lines are not drawn. No specific devices for people, and then we increase risk because people's system can get stolen, people's mobile phone can get stolen. People are leaving the office so late in the night, they get robbed, and that's all. And it goes. You can't even remote wipe because you don't even have such facility. And then exposing your clients, exposing so much vital information that you probably don't even have, you can't even account for. Then it's also a big issue. People overlook physical security. How are you storing files? Who have access to it? The powerful office secretary, the powerful HR. You need to be able to draw the lines there. Risky data sharing practices, things that can be shared over emails. Are we encrypting these emails? Are we encrypting these documents? Are things so sensitive that maybe sometimes we need more than just being able to share them in raw text? Or are we just sharing WhatsApp to WhatsApp? So where we don't even draw the line between what is professional and what's not. There's also issues around disclosure error where we attach wrong documents to the wrong person, expose. Imagine maybe it's a paternity fraud where things are being contested and then you pick that lab DNA test, send it to someone else who have no business knowing, And I mean, things really do happen. We cover it up, we don't escalate issues, but things really do happen. Quite a number of times I've been pulled into scandals, even within law firms in the country, where, for example, whether they are taking off grid completely because there are really no strong enough resilience measure to stay back on the line, and then their entire infrastructure gets kicked off completely. And these are things that happen. Of course, nobody talks about it. Again, another issue is mixing personal and business data, devices, WhatsApp, text messages. We need to be able to draw the line. I mean, this thing sounds so trivial, but it's a big problem. It's a big scandal when the ship sinks or attacks. Then international data transfer is also like a big issue. Some of us use different tools, different service providers, data stored in different countries. We have zero idea, we have zero visibility into the infrastructures that we use. And I wish I go into this because this topic in itself is like an entire masterclass and the kind of risk that we expect to where there are no laws or data protection authorities, where rule of law is like a problem with ignoring security. And again, the knowledge of the law is not enough. And for me, it's always like the biggest thing because I think sometimes as lawyers, we don't know when to stop. And I guess it flows from our training where they say, as a lawyer, you must know everything. But hey, you need to know what you know and what you don't know. Make admission and be simple about, be humble about it because of an opportunity to learn. So for those, there's something I call third-party risk management. And this goes beyond just technical stacks. It's about the people you work with, the people you engage with, the service providers you work with. What measures do they have in place? Are you working with a law firm who you have built an entire infrastructure where you take care of your client business seriously? And there's a law firm on the other side who gives no roots, where employees don't have their own systems, for example, and they use their personal systems where the lines are not drawn. And then you do everything right. But because you're working with this person on the other side, everything can go from 100 to 0 and beneath that. But it's also very important for us to genuinely build capacity. Trainings can be boring. Trainings can be not so engaging. 20 minutes I'm using to speak right now, it's not what I would want to do if I really want to walk people through. So we can gamify learning experience. And that knowledge of the then we need a procedure, we need a register, we need a whole mechanism to be able to track because not everybody will reach out to you through your dedicated channels. People will reach out to you outside of this. But also very important is for us to, I talked about poor disposal of information. We need to do that. But also to socialize with, it's easy to say you have a data protection policy on your website, but then it's even not reflective of the things that you do. It doesn't even account for the technical infrastructure that you have. Without contextualizing, without even understanding what we do. Again, the knowledge of the law is not enough to do these things. Another we need to also think about the risk. We've talked about everything that is wrong, but what does this really mean for us? From the case studies we've seen fines and penalties, we've seen reputational damage, and sometimes it's hard to put economic precision at these numbers. I mean, it's fine if you don't have shame, but the truth is, it spirals into things like loss of business opportunities. Because if you know as a law firm you have poor privacy practice, there's certainty I won't engage you on an enterprise. Something demanding increased level. It's not, I mean, it's not report is just complying with one application. It doesn't tell me how much of a privacy program you've built, the maturity of your privacy program. It doesn't say anything. You've only complied with one requirement of the law. And for anyone who has worked on a privacy program, you know it's a marathon. So financial and IP loss, everything can go from 100 to 0. Operational disruption. I've seen that happen with a number of law firms where I also get pulled into these situations. And regulatory scrutiny. Olumide mentioned regulators paying attention. And it's not just the data protection regulator, it's also about the consumer protection regulator. But also the fact that you sue. In the second case, it went on for 3.5 years, 5 years. That's not so far away. I'm going to see these things manifest over time as people become more aware about the risk and the danger of what they are doing. I have just 4 minutes left. I really want us to practice this. If you have your mobile phone with you, you can try to scan the QR code. If not, I'm going to try and paste the link in the chat box. It's a simple, well, maybe phishing test. And phishing basically is, we've all received past about this Arabian prince, but it needs somewhere. So now the money needs to go somewhere and they need you to help them keep the money. So now what we are trying to do is, what we want to achieve is, and it's just about 5 minutes. It's not going to take more than 5 minutes of your time. And that's why I try to really rush everything I had to say. You can click on this link. I'm going to stop talking and things can go on behind the scene. But if you complete it, you can just share your score. Don't worry, no shame in here. And there's a whole data protection obligation. No shaming. C1. So you're going to see emails that are genuine. If it's a genuine email or if it's not a genuine email, they're just about 8 questions. So we can play with it. It's also something that can help us improve our security measures, awareness about these issues. And I'll be really interested to see a lot of people take this test to also let them know where they are. Even for the best minds, sometimes you all make mistakes as well. At this point, I'm going to try and shut up and then sit things over to Nemesi. Thank you.
Thank you so much, Mr. Lawyer. They're always very, very interesting, enlightening, insightful listening to you speak. Like I was nodding my head like an agama lizard. I just kept going this and this. I don't know if other people were doing it, but I was also taking notes and questions. Yes. So thank you very much for that. It's been an amazing time. So lots of information just thrown at us. I was asking for questions to be shared in the chat box. So while we are undertaking the phishing link test, please let us take it seriously because we assume we know, but this training session is to make sure we understand that we can also be easily treated. I've taken this phishing test and it was Mr. Loide that also put me to the test too. And I don't think I passed the very first time, did I? I don't know how well I did the very first time. So yeah, so it's please let's all encourage ourselves. Let's make sure we do it. There's no shame here, just so that we can get better at what we are doing already. I'm just going to jump in quickly to some questions that have already been put out there. And thank you, everybody. We are seeing your messages coming from Abuja branch, Lagos branch, Warri branch. Thank you so much. Port Harcourt, thank you so much for being here. So we're just going to jump into a few questions that we had. I'm not sure how we can take all the questions, but let's see. And I would address this question to Mr. Oloyede. Under the data privacy laws, is it proper to keep a copy of each legal document that a lawyer prepares for his clients for the record? And going also back to something that Mr. Babalola had asked, first of all, is it proper to keep a copy? And if it is, how much time would you suggest? I know the bar hasn't guided us so far, but in your own experience, how much time do you suggest that that document should be kept, and in what format? I've just adjusted the question to be threefold now. Is it proper to keep a copy? If yes, how much time do you think we should keep the copy for? And in addition to that, in what format should we keep this documentation? Thank you very much, Mr. Oluyede.
I mean, I know Lumide is like really familiar with this, and there's like a joke we make in the privacy community that the response to every question is it depends. And that's where I start from, because honestly, it depends. But first, you don't need to know your own data. Do you know your data? Let's start from there. When you have the self-awareness about knowing your own data, and then that's where we now go to talking about what the retention period should be like. So, determining retention period is contingent on so many factors. There are retention periods that are specifically specified by the law. So, for example, things that have to do with transaction data. You see that under anti-money laundering law, counter-terrorism financing, and also under CBN regulations on anti-money laundering, and you see something like 5 years. And in Nigeria, for example, there are over 700 retention periods spread across different laws. So first, you need to know the kind of data that you process, and then from knowing your data, you then know what retention periods apply to your data specifically. But outside the retention periods prescribed by law, there is also the thing around statute of, is Rusty and Olumide can please bail me out. That thing that the average time before you go to court on a particular case, is it statute of limitation?
Yeah. Yes.
All right, thanks, I appreciate it. So there's also something around statute of limitation, which can also inform how long you keep some categories of data. Like, okay, if you have an employee or an ex-employee, for example, they have like this certain number of years before they can go to court. But after then, it simply means you might need to just dispose that data itself, or you archive it in such a way that you no longer have access to it, or at least extremely limited access. But beyond that, you can also have business needs dictate how long. If you have a 30 years relationship with the client, for as long as the relationship lasts, you have to keep the data. So, and these are just 3 examples that I'm giving. There are more factors that determine how long data should be held. So again, know your data. When you know your data, then you know what particular rule apply to it. Is it the type of data where there's like a legal obligation on you to keep for a certain period of time? Is it the one where it's the contractual elements? For as long as we're in contract, for as long as we have business needs, we need to keep it. Because you can't set 5 years for a retention period for a client where you have like a whole 30 years relationship for. They may ask you, here's a copy of my will, and you'll be like, oh, I deleted it after 5 years. Who sent you? So, I mean, all of these things, it's not just like common sense, but it's also making sure we're rooted in understanding of the things that we do. So first, we need to know our data. And by knowing our data, we know the kind of retention period we need to prescribe.
Thank you so much, Mr. Oluyede. Thank you. Now over to you, Mr. Babalola. We have a question. So, you made a reference to a matter where there was a divorce matter that was ongoing. So the question says, where you've tendered very sensitive WhatsApp messages as a proof of adultery, but data protection objection was raised by, I'm assuming it was the opposing counsel. Is the court precluded from using that evidence due to data protection laws? Can we say that data presented in courts as part of a divorce matter, the court is precluded from using that evidence due to data protection? Is it protected essentially within the court process? Mr. Babalola, over to you, please.
Yes, there's actually a case like that that's currently at the Court of Appeal. We did it at the High Court, and one of the issues, in fact, the wife, the spouse got judgment against the husband for attempting to not to use those pictures in court, but to share it with a third party. Now, privacy, data protection, they have exceptions. They are not absolute. So, and the very first rule with data protection is there must be a legal basis for you to use data. Any data you want to use, find a legal basis. So in litigation, every party has a legal obligation to provide evidence. And legal obligation is one of the legal bases of data protection. So you cannot raise a data protection. And even if you raise the data protection issue, it falls under the exceptions under which you can use it. And the person using it has a legal basis. And there's no Nigeria jurisprudence. Unfortunately, Nigeria's jurisprudence does not tackle how evidence is obtained. Unfortunately, some other jurisprudence will tackle it. You cannot use illegally obtained evidence or evidence that would really violate other people's rights in some other cases. I'm currently doing my PhD and I'm comparing the jurisprudence of South Africa with Kenya with respect to privacy, and Nigeria also. And you find those jurisdictions where the court has actually rejected the certain evidence because they violated the way they were obtained violated privacy. But Nigeria jurisprudence does not recognize that yet, which I'm privy to. So, but even in spite of that, data protection, privacy is not absolute. Somebody who is filing for divorce on the ground of adultery has the legal obligation and duty to produce evidence to show that the allegation of adultery is true. Either asserts must prove. If the law give you a burden of proof to establish adultery, then you will bring in all this evidence to show adultery. So in that case, the adultery will not trump, data protection will not trump the use of such an evidence in court. Inem, are you still there? Is she out?
Yeah, I think there's this question around that the data protection act applies to only electronic data. That's slightly incorrect.
Oh yes, yes, I saw it too.
It also applies to even data that exists in a non-digitized format, but if it exists in the filing system. And I think what the filing system means sometimes can be so confusing. And I don't know if I can go into the merit of that video, but yeah, it must exist in the filing system, which means that it's like some elements that's just like an attempt to be so deliberate by its organization and all of that. And that's what that means practically. So beyond data that exists in digital formats, if you have filing system like law firms do, like public hospitals do, data protection also applies to you. So,
I think all that
just even remember that like there's a default right to privacy under the Constitution. So even if you're trying to escape because data protection law wasn't so specific, remember there's a bigger privacy right, which it's more encompassing than data protection, which is more limited.
And even in addition to that, under the current Data Protection Act, Nigerian Data Protection Act, filing system has been taken away for whatever reason. So whether or not data exists on paper or exists digitally, the act is applicable to it. So the person is also asking in terms of electronic data, how would Nigerian align? So yes, in addition to what Ridwan said, so I think every law firm must know thyself. Every lawyer must know thyself. You know the kind of practice you have. Some law firms can afford, they have big storage facilities, they have big offices, they can keep files for years. I want to look at data from the prism of files now. I don't want to call it data. I want to call it files. I want to call it documents. So if you have the storage facility for you to keep concluded decisions, concluded files in your office for 30 years, you know you can keep it because you think you need it after 20 years. I don't know what for, but if your business can justify that you will need such a document, then it's on you. But electronically now, there are so many electronic storage facilities that you can use, paid, and some free that you can keep. And even in spite of that, it is the risk involved that is the problem. Because the fact that you keep it electronically does not mean people cannot hack it. Just imagine you are finished dealing with a client 10 years ago, 15 years ago, and somebody comes to hack your system and now brings out such. Imagine, okay, we're talking about divorce. People who have divorced, their children have grown up. They divorced under terrible circumstances. Their children are now grown up. Maybe they are not even married. It's at that time that somebody now hacks your own system, brings out such sensitive information and begins to publish it. How could you even feel yourself? Such systems should not even exist anymore. Such documents should not have systems anymore, even though it's electronic. I think Inem is back.
Yes, I am. Thank you so much. I was struggling to unmute myself. Thank you for all the information that has been shared so far. It's been very, very interesting. But I would like us to just give some practical examples. And well done to everybody who is getting on the phishing link. I'm seeing 5/8, 6/8. So I haven't seen an 8/8. Olaide Babalola, well done. It means that you're already a data protection and privacy professional, So well done with that. Please, I will encourage everybody who has been on the call here, who has not already joined that link, should click on the link and let's try our hands out at it. There's no failure. Money will not leave your pockets. Trust me. Let's just try. But I would like to talk about a few things. I'd like to ask a question. When we talk about disposing, the format for disposal, proper disposal of data, right? Can you please deep dive into how you would expect a small law firm as well as a big law firm, but small law firms, they don't have their shredders, they will normally just tear this up. And if you want to say that, a small law firm is actually keeping to proper data disposal, if you're using paper and also if you're using electronic means of data, what would you suggest? I'm opening this up to any of the speakers before we go on to other questions.
I mean, if I'm going to take a quick stab at that, first, disposal means stop letting people sell your papers to the senior guy. And this may mean first being able to, there's a whole, complex and not even more expensive process like degaussing, shredding, and all of that. But there are also like manual shredding tools that can help you shred paper into bits without being almost entirely recognizable. So that's always going to be a key thing. So if you can go for cheap solution that can allow you shred, you don't even have to get like the expensive one that get out every time when there are too many papers that it's been shredding. So you can get cheap manual shredding tools that can help you chop things into bits. I think that's really efficient. Stop using the manual, or is it templates? And people call it different name depending like cultural, but stop using it stop recycling papers. I mean, it's great to recycle paper. Maybe you're pro ESG. I mean, part of your ESG objective, but we need to be clear and do it from a place of knowledge, such a way that we're ensuring that even when we dispose refuse, we can't dispose these things alongside it. Or when we do that, we've already made attempt to like shred. I know there are like manual shredding tools that may take a longer time to do, but it's way better and saves us problems. And then when you have the money to invest, you can actually invest in the proper shredding tools that automates it. You basically just put the paper into it and it shreds it out completely. Yeah.
Thank you so much for that. Then I have a question, like, is it, when we're talking about CCTV notice, right? They have a right to use the CCTV in their offices, but then the attendees, people coming to the office also have a right to be aware. I would like you to talk about the location of this CCTV notice. So let's assume it takes you 1 meter to walk into an office, right? And let's assume the CCTV notice is behind the principal's chair. By that time, you've already gone through being recorded and things like that. Does that satisfy data protection policy, or is there a particular location for these notices to be placed in order to actually satisfy it? And is there a size for that too? Mr. Babalola, please, that question goes to you.
I think this is a matter of fact. And the requirement to have CCTV notice is rooted under the principle of transparency. Simply be transparent with the way you process people's data. If I have to walk into your gates, if I have to walk into your reception before I will know that there's CCTV in the compound, that's already a breach. That's a matter currently before the court. I can't speak so much about it against Ebano Supermarket. Ebano Supermarket in Lagos, whoever knows where they are in Lekki, they have CCTV in their, while you are parking, they have CCTV, but you wouldn't know. And you know what people do with CCTV. If you are on Twitter, there is something that is called, there's a page, or there is a handle that is called CCTV idiots. Those people pick CCTV footages and post it on social media, showing how people who are unaware of CCTV in certain places and how they, there are things you do when you don't know CCTV. So I think it is just right for you to put it, first of all, when people are coming in, a very conspicuous place, and it's just not one notice. There should be many notices so that you are warning people so that you know how to behave on these premises. It's not only for security reasons. It's not only for crime reasons or criminal reasons. It's also for them to comport themselves. If you see some people, the way some people eat in private, and you see the way they eat in public, you will know that the fear of CCTV is the beginning of wisdom. And the way women also adjust themselves also. I use one example very well. The woman got off from a car in a compound, in a business compound. She got off from a car and she was adjusting her upper part of her body, but she didn't know there was CCTV. And you can imagine how embarrassing that could be and how invasive it could be. So it's just to have it in as many places as possible. And if you check online, you will see sizes of CCTV notices.
Yeah. Thank you so much for that. Now let's talk about, you just talked about breaches, right? So instance that there are breaches that have been your own, let's say your law firm's data protection has been breached. What are the steps to take? Can you just give us step 1, 2?
Okay, so Ruben, please go ahead. I didn't know you were going to touch it.
Yeah, I mean, I was just going to say that when Yawa gas, the first line of response is, you have to stop the bleeding. And stop the bleeding means first, trying to stop whatever the source of the breach might be. So let's give an example. It could be a ransomware attack. It could be a DDoS. That's distributed denial, which can bring down your critical infrastructures. So when there's a breach, whatever it is, I mean, sadly, we don't have a guidelines on what qualifies as a data that they can key from what we've set up. From an operational point of view, simply means first you need to have like an incident response plan, because yes, Yawa just posted and we need to be able to respond to it. So the incident response plan, for example, we document the fact that yes, there's an incident response team. And once this has been escalated and the legal team has confirmed that it's a breach, because the lawyer ordinarily should be able to know if it's a data breach. So there are two things. You can have a security incident and you can have a data breach. So a security incident is a broader word for anything security related, but it becomes a personal data breach when there's personal data involved. So when there is a security incident, for us to know if there's a data breach, is the first question we ask is there personal data involved? And once we can establish that there's personal data involved, then that means there's a personal data breach. And once we've been able to establish that there's a breach, it means first the legal needs to check again. The nature of the breach, does it trigger the one that requires like notification? In Argentina, in Uruguay, if you look at the guidelines, you'll find that sending an email through BCC, for example, instead of CC, is enough to trigger an obligation to trigger notification to the regulator. So that's something. So once you confirm whether you have a notification obligation to the regulator, reporting obligation to the regulator, a notification obligation to the data subject, because some law also requires that you also notify the data subject, especially when it poses high risk to them. Think of something like DNA sample that was part of like a paternity fraud case, and then this slipping out of the crack. So once you're able to establish that, then the next element is then, again, from an operational view, while you're taking care of the legal issues, you also need to fix the operational points, which is stop the bleeding. You need to stop the breach from happening. You need to take evidence, which means you might need to bring in digital forensic experts to come in and start looking at what the problem really is. Then once you're done with that, and you're also at the same time you also need to like issue notification. Depending on how big size you are, you need to notify the entire world. Put out a statement. This is what we're trying to do. This is how we understand so far. This is how we're managing it. So, and once all of that is done, and you've been able to go past the most difficult phase, there's something we also call like the post-incident lessons, where you then reflect on what has happened, what are the learning moments, what are the learning points, what do we need to do differently. But that's on a very comprehensive level. You can have something as tiny as attaching the wrong document. If you attach the wrong document to the wrong person, or even to the people on the opposition side, what you have to do is first, admit that there is casala already. And once you figure out that, the problem is the problem, then the notification obligation kicks in. Like, there's really no second guessing about this, because it has happened. You've harmed someone who shouldn't have access to something. You give it to them. So how do you fix the side of the people who might probably be involved with this kind of disclosure, for example? You also need to notify them to let them know, and also let them communicate to them what exactly you're doing to mitigate, the whole issue. Are you going to pay damages? I mean, damages don't fix things like that. It's gone for life. People can replicate, people can duplicate, they can also share with multiple people. So there are just some things you don't pray it ever happens. And when it happens, you just have to respond some way.
Thank you very much, Mr. Oloyede. Now, I would like to ask a question. I like to ask practical questions, right? You know, one of the key rules of data protection and privacy when we are working is to separate personal and business data. However, in reality, that's a bit, those lines always get very blurred. So let's talk about practically how we can do that. When you're dealing with, for example, and I'll give, let's use WhatsApp as an example. Right now, we know that WhatsApp is a tool that we use for working. And the same WhatsApp you're using to message your mom or message your spouse, that's, in fact, sometimes that's how your clients even first reach out to you before coming to the office or having some sort of formal engagement. What would you say would be the best steps that we can take in order to reduce the risk of these breaches? Should we have two separate phones? Should we have two separate WhatsApp? What would you suggest? The computer we use for our home businesses, where we engage with our children, give our kids to play with, we shouldn't use that same computer for our work emails. What are the steps that you think that we can take practically in separating personal and business data? Mr. Babalola, let's have you on that one, please.
The Bible says that if the God begins to make mark of iniquity, nobody can stand. So the same thing with data protection. If we begin to look at compliance from the way you should look at, even me, I am not qualified to speak in front of you. So first of all, even in developed countries, it is difficult to comply with these things because the standards are critically high. It's not possible. Even if you get a separate WhatsApp or you get a separate phone, mistakes do happen. And again, it is still the same human being that will operate this phone. So there's no how data breaches can never be 100% avoided. The biggest of the companies in the world, they have data. British Airways, what do you call it, telecommunication companies in Italy. Everybody has suffered it one time or the other. You most likely, but it's just like the election petition lawyers would say, substantial compliance. That's what we need. To be aware, such that you are not using your office laptop recklessly. So, I mean, if it's office, if it's official laptop given to you by office, you shouldn't even use it to watch movies. Just leave it where it is. My wife works with the government legal department in the UK, and our official laptop is no-go area to anybody, even not even me. I can't even touch it because of how much they take this thing. So it's not for us to avoid, it's not for our lives to stop, but just for us to be conscious of this thing and try as much as possible to be compliant, to be careful, to be circumspect in the way we handle whatever device has other people's personal data. It's just the consciousness. Sometimes these things just jump at you. Once you are conscious, it jumps at you when you see something about to happen.
I quite agree. Thank you so much, Mr. Babalola. Now we have just run out of time, and there's just one more question that I would like to ask before, and then I would also like to ask a favor of our speakers. So question number one goes to Mr. Oloyede. How often do you think we should update our software system? Is it every time we get a prompt that we should update? So the moment between the time we get a prompt and when we eventually update, are we not obeying data protection policy?
Yeah, I think first is, what's the motivation for even updating in the first place? So you realize that you update because, or when you get a prompt to update, it's simply because the software or the system manufacturer is saying, oh, they found, it may be like a program, a feature that has been improvised upon, but it could also be because they've discovered vulnerability in the product. And rather than allow you to get exposed to that vulnerability, a patch is released, which is like an update. So the patch essentially blocks that vulnerability. I mean, that's just me simplifying it, oversimplifying it. So the patch blocks the vulnerability and you get triggered to update. So when you get a trigger to update, I would definitely advise that you do the update, especially if for example, the system or the app provider is giving you an update and it's giving you like a brief information about the nature of the update, that bug fixes, for example, there's a very good chance that it's like a major vulnerability patch that's been fixed, and it's really encouraged that you do that, such that you don't then become the person or the entity who then exposes, who then become vulnerable and then exposes other people's data, and both the business, both the personal, and all of that. And then we don't have a situation that spirals into a complete absurdity.
Okay, thank you so much. Now, this last thing, I've not seen any other questions in the chat box, and we've actually run out of time. But I would like to please request that both speakers, Mr. Oloide and Mr. Babalola, please, can you give us examples of measures that we can take against that, the measures that we can put in place against, for example, generative AI, to show that our law firms are up to date. So I know that you're expecting that in clauses. If you have that, you can still please post it in the chat box, or you can talk to us about it in your rounding comments. So the questions that we're looking for would be examples. So we're taking away the knowledge. Now, can you help us with the practical steps? What kind of clauses should we put in place for anybody that engages with our law firm? Know that we have taken measures against or on policies for use of generative AI. Our incident response plan, where can we get a template that can guide us, so to speak, and also examples of data protection clauses that law firms can put in their engagements with, if, for example, in any agreement that they are preparing on behalf of with a client or with a vendor. If you can please just share. I know that is a bit out of what we had asked you to come in here to do today.
Because we share it.
I'm not going to allow you to throw me under the bus today.
Please just share something.
What we can do is to share maybe links to really incredible resources that we can play with, because in as much as templates help, we also can afford to be we can't allow you to do too much for us, because when data protection is hard, and when it comes to data protection, a lot of things are context specific, because that thing that you adapt for one person, not just fit into the context for the next person. And that's why the message has been we need to build capacity. It's easy for me to give you a template of what is something, but then it doesn't reflect your own reality. And then you realize that by the time you try to operationalize that, it's not just working, because it just cannot work, because you can't take the drug for headache for stomach ache. And if that's a good analogy, but we can share post events, we can share links that can guide us about how to get started from the basics to then building up internally what our privacy program could look, and also it could also contain links to useful templates that we can play with.
Awesome. Thank you so much. So after this webinar, we'll definitely be sending that out along with the slides. But please go to www.privconnigeria.org and get registered for PrivCon. It's a privacy conference that is taking place next week. I'm not sure if it is physical or if it is hybrid.
It's hybrid. It's
hybrid. Okay, yeah. So everybody can go there. Some of these questions that you're asking, because 2 hours or 1.5 hours is not enough for us to drill as deep as we could possibly go. So you go to the PrivCon and get some of your questions answered. On that note, I would like to say thank you very much to everybody who has stayed with us from inception till now. Your questions that have been asked, thank you so much for asking. Thank you for being active. I would like, Ajibola has his hand is up. Can you unmute yourself and ask your question?
You can't.
You can't. Okay. Do you have a question? You can put it in the box, the chat box,
You can now.
Okay, Mr. Ajibola, please ask your question.
Okay. Good afternoon.
Good afternoon.
All right. I want to ask with respect to on this data protection. Is it possible for you to sue an organization that is disclosing someone else's private data to you? For example, maybe someone else's account details. Maybe a bank is sending you someone else's account details, or maybe using your own either email address or phone number in replace to another person, and you've complained and it didn't stop. So is it possible for you to sue such an organization?
Of course, now we have sued now, and we have gotten damages. So please sue. I mean,
what
Mr.
Mr. Babalola intended to say is that you should hire them so they can sue on your behalf.
But you know that it's not his data that is in breach. So
it's a third party. I mean, even aside privacy, there's also nuisance.
Yes. So I mean, the one we did, they kept on, because all solicited messages, they are privacy invasion. So the one we did, this person was getting another person's transaction alert. Yes. And they made that argument. The lawyer made that argument in court. That wait now, the alert is not your own, so it is not your own privacy. And the person said, come on, it's my telephone number you are sending it to. And I was getting irritated and I was getting disturbed. And I complained, and you continued. And it was on that basis that the court even awarded damages. The fact that they complained and it didn't stop. So, I mean, it's not just about your data. If somebody continues to send you unsolicited messages, it's a violation. Yeah.
Thank you so much. Okay. So, over Ayotunde, I think, Mr. Chairman, we can have, take this as the last question before we round off, because we're also taking into consideration that we have one more question for Mr. Ayotunde. I can't see your surname. I'm so sorry, but please unmute yourself. Ogundare, please ask the question.
Yeah, good day, everyone, and thanks for this opportunity. My question is, in the corporate environment, like a building or a facility where there are several companies there, like 4, but a particular company installed CCTV at the gate and at strategic areas within the compound, and there are no posters or anything saying that, okay, CCTV is on and all of that. What can be done in that area? And they are insisting that they are protecting their product or something from being stolen by their own staff. But it's not only their staff that has access, to the building or to the facility. So the CCTV
one of the requirements,
right at the gates and everywhere.
Because of our time, one of the requirements of whoever wants to place CCTV is to show who the controller is. In the CCTV notice, you are supposed to disclose the controller of the CCTV is so. If they don't disclose, if anybody gets into trouble, all of you in the premises they might sue you first before you go and start telling the court that you were not the controller or something. So you can also, in fact, you can take them up on it, because whatever happens would affect you one way or the other. Even if the CCTV is misused, all of you are in that premises. So take them up on it. Or you even send a petition to, before going to court, you can send a petition to NIDA, to NDPC, and copy them. Maybe it will make them it might just be out of ignorance. And you can write them a strongly worded letter. Let them understand the implications of it. Some of these things are ignorance, not out of arrogance.
Over to you. I mean, I thought you were going to speak. So maybe Inem is or maybe it's me. Can you hear me?
Yes, I can. I'm sure we can hear you.
Okay, so that means it's Inem's network issues. Okay, so I think at this point we've come to the conclusion of the session. I'd like to thank everybody who has joined. It's been such a wonderful event, wonderful audience. Even I am to some extent what do you call it, a privacy professional. I mean, to a large extent actually. But I've learned quite a lot of things during this session. I'm sure we've all learned, not just from the facilitators, but also from some of the questions that have been asked. So I'm grateful to everybody who has joined. I'm grateful to the facilitators, my two brothers. One is my very senior brother, one is my another senior brother, even though he says I should not call him Ebo. I'm grateful to the both of you for agreeing to speak and for what you've done. I'm grateful to everybody that has joined. Mr. Babalola, you had spoken about a policy or some document by the bar. I'm happy to say that the Tech and Law Committee, with the permission of the SLP, is putting together policy documents for various aspects of technology for the legal profession. So some of the issues that you have raised, I know that we're actively working on an AI policy. We are working on an IT policy. Part of the IT policy, both of them would include privacy provisions. But the IT policy is more likely to include a more detailed privacy protection provision. And we are careful about doing just one document separately on data protection, because sometimes if data protection is beyond just technology, it includes other aspects. But I'm sure that following these conversations, we'll discuss with other committees and we'll jointly put together a document, a policy document that covers data protection in total. I'm thinking that when I finish this, I'm going to send it to you and read one. And if people at no cost, because I'm not being paid to, it will be public service, as I've been providing public service to everybody. Help us review. Of course, you're going to be part of the stakeholders who are going to approach to validate and review. So thank you very much also for in advance for what you've done. We're going to send a detailed email stating a summary of what has been discussed to some extent, a link to the video recording and the slides. We're also going to send a survey. Like I said at the start of this session, please answer honestly so that we can learn and do better for our next sessions. If you have further questions, you can ask, and we're happy to explain them. You don't have to put your email in the box. You already have them when you registered. So thank you all very much. And well, have a great day. Happy Easter. Oh, and register for the SLP. Register. Go to slp.org, NBA-SLP.org and register. If not, well, you're on a long team.
Thank you very much, Mr. Chairman. Thank you so much, Leonard Silverman. Thank you, everybody. Have a nice holiday. Bye.